Are you prepared to die? Well, you need to be, because it's inevitable. And you never know when death could become relevant to you and your family. Death can come when it is least expected, while other times it's a long road there. As you can see from this graph from Insurance Watch, most of us will lead a long, fulfilling life. Now, let's take a look at the CDC statistics, which show us the leading cause of death for young adults are accidental deaths. So it's never too soon to start planning for your death and getting your affairs in order. One aspect of death is your estate plan, as in what you leave behind for your loved ones to handle. As a probate paralegal for over 13 years, I've handled estates for people of various ages. Grieving a death is hard enough, so let's discuss how to remove a layer of hardship for the ones we leave behind. When you die, someone has to handle your affairs. Many times a probate must be completed in order to do so. So, what is a probate anyway? According to the Florida Bar, any asset in a person's name alone at death is subject to probate. This can be a costly and timely process that must be handled through the court with the assistance of an attorney. So let's say you tragically pass away and you have $5,000 in your savings account and $1,000 in your checking account. No one can access that unless you have the right designations on your account. So you're going to have to hire an attorney to probate your estate, and by the time your family and your parents pay the attorney and the court fees, there's going to be no money left for them to pay for your final costs. So let's discuss the importance of estate planning and what it is. It refers to wills, trusts, power of attorney, healthcare surrogates, deeds, pre-need guardian designations, partnerships, and business entities. According to LegalZoom, only 45% of adults have estate planning documents, which isn't actually bad. That's pretty good. My husband and I have our estate planning documents prepared, and the most important aspect of that, in my opinion, is the designation of a guardian for our minor children, should we both pass away. If you're a single parent and you unexpectedly die, what's going to happen to your children, your assets, your house? So these are things you want to think about and things you want to prepare for. Even if you're a young adult, and your parents die, what happens to your minor siblings? So it's something you might want to talk to your parents about or your grandparents about to make sure all your affairs are in order. And let's revisit that car accident. Say you get in the car accident, you're incapacitated, you can't make decisions, you can't access anything because you're incapacitated at the time. Some estate planning, like the power of attorney, the living will, the healthcare surrogate, those will have designations on it so people can act on your behalf while you're not able to. So it isn't just about when you die, it's also about help when you're incapacitated. Preparing estate planning on your own is actually an option. You can go through LegalZoom. They offer documents and they offer some online consultation. There's also paralegal clinics where you can go and get things done at a lesser rate. But please don't let the cost deter you from getting things done now, because it'll cost your family so much more in the long run to handle things after the fact. So how can you help avoid having to put your loved ones through this tedious process? Wouldn't it be nice to ease some of their suffering with a little pre-planning? It would. According to the Orlando Law Group, trust administration is one way to avoid probate. In its simplest form, everything is just in the trust's name instead of a person's name alone. So when you pass away, everything is administered through the trust, avoiding probate. Another way to do it is titling of assets, which we can all do without an attorney. We just need to contact our institutions and get things retitled. Remember the example of your death and someone trying to access your money and not being able to? By simply adding something like payable on death or a beneficiary designation, all that person would need to do is go to the bank, present a death certificate, and they would be able to access your funds. So it's something as simple as just adding "or" on your account. So you or your mom, or you or your sister. Or you could do something like payable on death. Upon your death, it's payable to whomever. Or you could do joint tenants with rights of survivorship, which is kind of the same thing, where you're joint tenants with someone, and then upon death, the ownership gets transferred over. It's all easy things to do. Beneficiary designations, you just have to talk to the institution and make sure it's possible. Because my husband and I had some Robinhood accounts. We were trying to have beneficiary designations payable on death, which ironically they didn't offer. So we had to pull our money out of Robinhood and put it into a different account where they did allow beneficiary designations. So be sure you check with the institution to make sure you can do that. So in these ways, you can avoid the need for a probate of your estate. If you happen to be wealthy, then you should see an estate planning attorney to get a sophisticated estate plan. But if you're like me and the majority of us, these simple strategies would work out just fine. So please don't wait until there is a need. By that time, it's usually too late. Better to be safe and prepared to ease the burden on our loved ones. So now that you know more about estate planning and how some pre-planning can be useful, who's going to see an attorney to get their affairs in order? Okay, well, how about retitling your accounts with beneficiary designations, or simply designating a healthcare surrogate or a power of attorney? You just never know.